Go! I know you guys are all excited. It is eviction power hour. I just decided to add in the word power just for fun. And we've got an all-star panel like we always do. Sometimes we have all three, sometimes we have two, sometimes we have just one. Tonight we get two. Two out of three ain't bad. Isn't that the old saying? So let's go ahead. We'll bring in Raphael with a round of applause. Raphael is here. And then Zach. Zach is here. Zach's got a fancy new set of headphones, so we know he's paying attention. He won't doze off. So thanks for coming, guys. Appreciate you being here.
Thank you for having us. Yeah,
There you
excited to
go.
jump
There
in.
you
Yeah.
go. We'll edit that out in post. Don't worry. That nice long pause. So we got Michelle in the background. She's keeping things clean. Make sure you post your comments. And don't, oh, we already got people posting. This is exciting. And just remember, I can't give tax or legal advice. You can, but the guys in the ties, those are the ones who can. So, guys in ties, remember that. So, couple quick things. One is a lot of changes since we last live streamed. I don't know how far we'll go into this, but one of the big changes is the LA City has basically next week their right to counsel act goes into effect. So in LA City, for certain zip codes, if you are at 80% of area median income and you're in one of those zip codes, and you're at risk of eviction at the unlawful detainer time. This isn't, you don't get an attorney when you're given a 3-day notice or 60-day notice. It has to be in unlawful detainer. You have to get that paperwork. So, guys, any thoughts on that? How it's going to be interesting with the right to counsel changes you expect to see?
Yeah, so it's going to, I think, create just another trap for the unwary in the city of Los Angeles. Failing to comply with some of the requirements of the right to counsel ordinance can impose attorney fees on unsuspecting landlords who maybe don't know the rules or don't watch your content, and they can really get hit with unbelievably high attorney fee bills, lose a case for something as simple as printing out a 2 or 3 page form from the internet and stapling it to the notice that they are serving. So I really do think that from the perspective of fairness, it does create serious traps for the unwary. It'll also cut down, I think, on defaults, but not as much as people might think. A lot of people already were getting free legal representation. There are a number of organizations in Southern California. And at our firm, the number of defaults that we would see in LA County is relatively low. Typically, it's people who've already let's say left, or people who have other issues going on in their life who wouldn't end up with a free attorney anyway. So I think that this is solving a problem that really was not that prevalent, and it creates huge liability for unsuspecting landlords.
Yeah, I agree with you. And Raphael, I'll let you chime in as well. So, what's interesting too, going back to what you mentioned, Zach, on unwary, one of the big things that landlords are going to have to be aware is there's actually a form they have to give now that is from LAHD, from the city, that lets the renter know about the right to counsel. And it must be delivered at the time they sign their lease. It must be delivered with the notice to terminate tenancy. So if you're given the 3-day, 60-day, whatever, you give them that. And if you don't, it becomes an affirmative defense against the eviction. And here's where it gets interesting. And Raphael, I'll let you chime in on this. But even if they wouldn't have been eligible for the program, the fact that they weren't given the notice gives them an affirmative defense. So go ahead, Raphael. Any thoughts on this new program coming out?
Yeah, that's absolutely true. I think I did a recent event at an office with it was an roundtable with a bunch of realtors in Brentwood, and we when we were talking about this law, we just I think it's just safer to just even if the tenant wouldn't qualify, you want to just post it on every single property, even if it's a single family home, multi-unit single family doesn't matter. You want to post it in a conspicuous place. take a photo, document it, just in case. And there's also a requirement that has to be done in the tenant's primary language. So if you know that the tenant's primary language is something other than English, and if they have that that form available in that language, there's a ton of them on the form. Then you got to give that as well, and then you should be just fine. If you don't, you could be subject to attorney's fees if you lose, and you will didn't follow.
Yeah, I saw that. It's an interesting twist on it too, that you would be subject to, if you lose, you're subject to paying the attorney fees. So just more of a reason landlords need to make sure they're reaching out to professionals like you guys. So that's a good point. You have to post the notice in addition to giving the notice to the renters. And so that makes 2 notices minimum that you have to post on a property. That would be the right to counsel notice and the LA City renter protection notice. It'd be nice if they actually combined them. It's a total of 4 pages. Maybe they could make it really tiny font and squeeze it on.
Actually, if it's RSO, you want to make sure you also post the RSO notice. So
yep.
Some properties must have 3, and then if you want a little extra credit, some attorneys hold the position that the statement of registration also has to be posted, even though that's not our firm's position. It says it must be given to the tenant at the beginning of the tenancy. But if you want to be extra safe, just go ahead and post all 4. Unless it's a single family home, then you don't have to do the RSO notice.
Yeah. So do you think LA City is going to hand out big bulletin boards to landlords? They can put those up and have all the pages of information they need to post. I jest. No, it is important stuff. And of course you have to follow the law and post it. And unfortunately, one of the downsides with posting all these different notices is it actually leads to confusion. The renters aren't sure what the heck all of this means. Landlords aren't sure. So in an attempt to make it clear, sometimes it makes it more opaque. So one more thing before we dive into questions. I'm probably saying it wrong. Ashagian versus Sepeda was, Zach, you waxed poetic on it last time we were together, but I think it's worth bringing up again. Let's talk about how that's affecting evictions right now, please.
Yeah, sure. So a lot of people are bringing motions to win cases that are currently in progress, and we're not seeing a lot of success for the tenants on those motions. But it's a good idea to try and get ahead of any possible argument that they could make. So if you really want to bulletproof the process, and with the proliferation of attorney fee provisions, you can understand why it would be a good idea to really bulletproof your process. You want to include the date that a notice is served on the notice itself, or include the date that the notice expires, some way of allowing the tenant to calculate when that period, let's say to pay rent, actually runs. There are a number of different ways that you can do this. It can be as simple as writing it in if you're serving it yourself. Our firm uses a different method of having an attachment with the notice that'll help the tenant figure out what day it was served on. But by and large, the number one takeaway is even if, so if you have a current case right now, don't panic. I don't think that it's necessary to dismiss. I haven't seen cases being, let's say, because there are thousands of evictions that are currently in the process right now, where this case had not come out, and so thus are operating sort of in a pre-Ashagian world. I wouldn't say dismiss all your cases, certainly not, but in the future, to avoid any kind of problem or any kind of argument, put the date that it was served or the date that it was expired, or do something to try and address that paragraph in Ashagian versus Sepeda.
Yeah, and to clarify what Zach is saying, to make it easy for people who aren't wearing ties like me, the case was based on the fact that in this case, I think it was a 3-day notice to pay or quit. So when you serve the 3-day notice to pay or quit, the renter needs to understand what the 3rd day is so they can actually pay it or quit. And it was saying it was basically ambiguous as to when that 3rd day was, correct, Zach?
So there was a large portion of the opinion. The opinion is like 30 pages long. and 29 of those pages are dedicated to more esoteric questions of law, such as when you have a final judgment from which an appeal can be taken, and complications of unlawful detainer civil procedure as to that. Okay, so that's really what the court was looking at. And then in one page, it went and said, oh, by the way, there's some issues with the judgment anyway, because there were issues with the notice, which was attached to the complaint. It didn't exclude Saturdays, Sundays, and judicial holidays, which is something that it has to include. And one of the problems that they said was that the notice didn't say when the period began or ended. And thus that could be interpreted as saying that it's not enough, for example, to say within 3 days of service of this notice upon you, that it has to say something like August 14th, or something, or by, let's say, August 20th, you have to pay me the rent, whatever. That could be one reading of Ashagian. That's a very small portion of the opinion, which is why there's now like 20, maybe 10 requests for depublication, or at least depublication as to that portion of it, because that really wasn't, at least as far as I can tell, that really wasn't what the parties were fighting about and discussing in Ashagian versus Sepeda. It was, again, about a somewhat esoteric piece of California appellate law that mixes with unlawful detainer, that then had one paragraph that may have implicated tens of thousands, if not hundreds of thousands of people in California, almost by accident.
So in other words, taking it out of context. that's kind of what they did. They took it, just pulled that little snippet out of there. It would be like a little TikTok video or an Instagram reel. That's all they did was that.
Yeah, that's right. Yeah, the sound bite, right? And so that, there's essentially some, maybe that's really what the appellate court wanted to do, but it would be an unusual way to do it. I think that really it is just the sound bite from that one paragraph led people to conclude that this was now essentially a new law that had just been written by the appellate court about the requirements for a notice. I don't think that that's a good way to make law. I don't even think that that's what the appellate court intended to do, but we'll see with regard to the requests for depublication what happens.
Mm-hmm.
Spectacular. Two quick things, and then Raphael, you're going to take this question from Cliff. So two quick things. One is, this is why you hire California Property Law Group once the rent is late, or once they're violating terms of the lease, or once you're going to go ahead and give a 60-day notice to terminate tenancy. You hire them then. You don't wait until you give some sort of notice and then they don't move out, and then you have to hire the eviction attorney. You hire them ahead of time, because they will make sure the notices are correct, so that if it moves to the unlawful detainer, that it's done correctly. The second important point out of this is landlords have no chance to know the entire law on their own. If it's taken you guys being in the court all week long and nonstop following up with the law in order to understand it, a landlord's not going to be able to figure it out on their own. So would you agree? Raphael, you have to
Absolutely.
agree.
That's why we're here. Definitely at this point, you don't want to do it yourself, given the new right to counsel, because your tenant's going to have a lawyer. So call us.
Yeah.
So
There you go. So the deck's stacked against you. All right. So we're going to start to dive into some questions. So Cliff has a big one. It kind of reads like a telenovela. So let's dive in. And Raphael, I want you to help us parse this one. So Cliff hired someone to be an on-site manager because there were 16 plus units, apparently not officially employed. So that's an interesting thing. If you hired them, but they're not official, maybe it was just like, I don't know, trial period. So the police busted his door after the neighbors heard his girlfriend screaming. Okay. There's more. He went to jail. Tenant talked to the girlfriend for 30 minutes at his place next day because he wanted peace in the building and feared any bad activity could have them evicted. Okay. Let's see where this goes. Manager came back from jail, thought something happened, talked to the tenant, then apologized, but got drunk days later, pushed the tenant, committed battery. Oh boy, this is not good. Keeps going. Police were called. Police aware of the manager since he goes to jail often. Okay. Now tenant is suing me, the owner. He has an incident report but didn't press charges. So this is why you need very effective screening processes, I would say. Turns out manager has a record. So here's where we get to the question, Raphael, I want your opinion. What legal financial risks does this owner face? And then there's an ongoing lawsuit for harassment in addition to this new one for battery that the tenant is bringing. So that harassment must be not related to this person, but to someone else. So what do you think, Raphael?
Well, it's hard to tell what damage or what their exposure is to this lawsuit without really reading the complaint. However, this is an issue that when it comes to our office, we usually recommend having your insurance company step in. A lot of times you might have liability coverage under your policy, and they do a good job of hiring attorneys and settle the case out for you. But these kinds of cases, they're very fact specific, and you would have to look at to see what the real damages of the person who's suing are. And yeah, it's honestly, we would have to see the complaint, see the allegations, and during trial or discovery, you would have to get into the nitty gritty about did the landlord act as negligently, yes, and did they act in a reasonable, as a reasonable landlord would in similar circumstances when they hired this manager. So without having more information, I'm afraid I can't really tell them what their exposure is.
Yeah, that's fair. No, that's a fair response.
But I would say if you haven't filed a claim yet with an insurance company, and if you have one, definitely do so.
Yeah, and that's another great point, and I appreciate you bringing up the insurance. The problem is sometimes landlords, especially those who are mom and pop landlords who basically buy another house and decide to rent out their past house, they don't let the insurance company know, and they don't have the correct insurance, or they've been a lot of non-mom and pops who have bigger buildings have been dropped by their insurance companies. And so no, that's a great point. So make sure that you have insurance, the right kind of insurance, and liability insurance. So Elise is here. Elise, good to see you. And this question we did address, but it was before Elise asked this, and it's a good question. We're talking about the right to counsel posting the notice, even for a single family home, or only deliver it when it's needed. And Raphael, you address this. Go ahead and address this again.
Right. So again, I had this question asked to me again yesterday, and I would say definitely post it. The reason is, this issue does come up. We had a case before where it was not the right to counsel form, but it was a renter's protection notice, and our office was sweating about whether or not, because our client said, "Well, it's a condo. Where am I going to post it? There's no common areas." I just wish that they had, so we wouldn't have to deal with the argument. So it never got brought up by opposing attorney. I think they forgot about that issue, and we just kind of did the trial without it. But I will say that just do it. Just post it, take a photo. And also just send them a copy as well. Why not over comply? That way you can just, completely circumvent that issue altogether. So I'm going to say that post it definitely, because that's what the law says. It doesn't say if it's a single family home, then you can mail it. So.
Yeah, exactly. And that's, like you said, a condo, you would just post it to the door of the condo and take a picture, because the renter is going to take it down because nobody wants that there. And then even if it's a $1 million, or not a million, $1 million monthly rent, like this could be like a $500 million house in the Hollywood Hills, and they're paying $500,000 a month. Like, the law does not separate them. You're going to have to give them an LA City renter protection notice and a right to counsel notice, even though they could buy a law firm if they need to, if they're paying that much rent. So, yeah. All right, let's see. Continue. We got lots of questions coming here. This is good. My new property owners have been harassing me. I'm disabled and live in RSTPO for all my life. They inherited me with the purchase. I've had my outside water locked when I refused to cash for keys. Yeah, that's harassment. That's a prime example. of harassment. In fact, the law in LA City and LA County, they have their anti-harassment provisions. That's actually mentioned in there, amongst other things. You can't reduce services, can't turn off utilities, can't call immigration services, which is something today that's very relevant. So, gentlemen, what would be your advice to Vigilant Bulldog on this one?
I would say find an attorney that specializes in habitability claims against landlords, and you might have some remedies. And if you have a eviction case, if you have an eviction notice already served, this will be a pretty good affirmative defense if what you're saying is true.
Yeah, and then there's a termination of lease now on the first, so it'd be rare. You are most likely protected, Vigilant Bulldog, under the RSO. So it would be pretty hard to believe that they could terminate your tenancy, but maybe there's a few things they could do. Ellis Act, but you can definitely reach out to Stay Housed LA. You can reach out to LAFLA as well and talk to legal aid. And these guys, if their client, as eviction attorneys, if a landlord came in and said they did these things, these guys would not take the case, because you don't want a landlord that's pulling this stuff, right, Zach?
Yeah, that's the thing. I mean, there are a lot of people out there who will do things that let you know why laws exist, right? Anything that
Yes.
says, anytime you see a battery that says, don't eat this, there's a reason that says, don't eat this. Somebody tried to eat it. And so, there are really, really awful people out there. Some of them are landlords, some of them are tenants, some of them are homeowners. And they're the reason why laws exist.
Yeah.
So, in this particular situation, it sounds like there are laws that are directly addressing the issues that you're facing. And as a citizen of a free country, you get to invoke the law to help you push back against people who would otherwise invade your rights. And that's a neat part of America. So unfortunately for you and me and everybody else, it can seem too frequently that, good legal representation is hard to find. But there are a number, like Christian mentioned, there are a number of really good free or low cost legal services who should be able to help you, because it sounds like it's going to be a 1-inch putt. It's going to be a very, slam dunk, easy way to prove tenant harassment, and should be able to, the termination of the lease. A lawyer should be able to help you out with that. It's likely not going to be effective. I can't say for certain, but given what I know, or given what you've said about the landlord and their conduct, I don't think that this is, let's say, the most buttoned up, most likely to be above board eviction that I've ever heard of. So I would get in contact with a lawyer, and they would be able to assist you.
Yeah, good advice. And Elise says she's confused, and I don't blame her. So she's going back. This is going back to the right to counsel notice, even when there is no default. Yeah. So this starts August 20th. This program. So that's next Wednesday, the same time we're going to be at the AOA trade show. A little plug there. We'll plug that at the end again. But that same day is when this starts. And theoretically, that's when you should have post this notice to every rental, multifamily, single family house, condo, every rental, just like you're supposed to post the LA City renter protection notice on every rental. Same thing. And then if and when there's a default and you're serving a notice, like a 3-day notice to pay or quit, the notice will go with that as well. So to be served again. And you guys can clarify this, but it sounds like to me, when the unlawful detainer paperwork is served, it should potentially go again, because the way it's written, it's somewhat ambiguous. It just says eviction notice. So those, to me, would be the 3-day, 30, 60, 90, 120-day notice and the unlawful detainer paperwork. But you guys are smarter than me. You let me know what you think on that.
Well, typically you would attach a copy of the notice and any attachments as an exhibit to the complaint. So anytime that you'd be serving the complaint, it would also be coming along as one of the many, many, many pages. Yeah, exactly. An
Exhibits.
exhibit to the complaint. So yeah.
And does that get served? But does that get served by the process server to the renter? Do you include the exhibits when you serve the, what is it, the summons and
So yeah,
complaint?
so the summon, basically what you're going to serve, there's a bunch of stuff you have to serve. A little outside the scope of the question, but basically, yeah, you would serve the complaint, all of its exhibits. Code of Civil Procedure 1166 explains what has to be attached to the complaint, and the proof of service is one such thing. Or excuse me, not the proof of service, sorry, the notice is one such thing. And with that notice, you would want to attach all of the different pages of the notice, right? So if you've got a city of LA renter housing, renter protection notice, if you've got a right to counsel notice, if you've got landlord declaration, escrow instructions, any other kinds of attachments, you'd want to attach those to the complaint to let the court know, hey, I also serve these. And then when it comes time to serve the summons and complaint on the tenant, those come along for the ride as an exhibit to the complaint.
That's good to know. And then the renter then has 10 court days to respond. It used to be 5 court days. Now it's 10 court days as of the first of this year. Raphael, what are you seeing there? Any changes with the 10 court days to respond? Have you noticed things taking longer? Or
Yes, a lot of these cases, what happens most often is the when it's posted, so you have to have 10 calendar days plus 10 court days. So that kind of roughly adds up to be about 25 days, give or take. Whenever the tenant knows they're about to be sued, they usually don't open the door even though they're home. And we would have to get an application for an order to post from the court, which results in adding in like pretty much a month to the whole eviction process. So a lot of angry landlords, but it is a law, and we just adapt as always.
That's it. And I'm going to do a video on the Right to Counsel Act or ordinance, and the renter has 30 days after being served the unlawful detainer paperwork to essentially reach out and get an attorney. So just to throw that in too. All right, I think this is a very good question from Jay, and that is generally speaking, out of all the cases you lost, what could landlords do better? And for the cases you won, what did the landlord do right? So I'm going to interject and say that it is incredibly rare that these guys lose. They hate to lose, and they don't lose often because they do a good job of screening and making sure things are done right. But it's if you lost one, you don't have to admit that you did, but if you did lose one, Raphael, what was it that went wrong?
Probably the best question. I love this question. It's so good. Yeah,
it's good.
So basically, it's 2 sides of the same coin. The cases that we lost, most of the time, it's because the landlord did something strange many years or many months in the past before there was even a problem, right? For example, the number one is an improper rent increase. So if you ever do a rent increase on your tenancy for your tenant, you want to do it in writing, and you gotta, if you're gonna give it personally, it could be 30-day notice. So if you're gonna raise rent for September, it's not gonna work. It's already August 14th, so you need to have 30-day notice, right? So you would have to do it for October. And if you do it by mail, if you can't get a hold of your tenant, you got to add 5 days for service. So that's a really important one. A rent increase done in 2005 that was bad could affect your case in 2025. So that's the number one reason. That's how they get you, really, rent increases. Another one is obviously when new laws pass, like for example, like the one that we talked about today, the right to counsel, they just don't know and they don't post, right? So that's another way you can lose a case. So basically, it's all the same. Essentially, you got to be educated on the notice requirements for the tenant, and another important one is when there's instances of there's laws that you got to follow that as soon as you become a landlord, you got to do. Like, for example, if you just purchase a property, you also have to give your tenants a change of ownership notice, right? So it's all notice. It's all notice, and not doing that, not giving the proper notice, and at the same time, if you do even get notice, sometimes you got to do it the correct way, right? And on the flip side of that, the cases we do win is when when our clients do all these things correctly, and we're actually able to submit a case to the jury, right, or a judge, then we can actually win on the merits instead of silly technicalities or losing on silly technicalities. So if all the instant win buttons are taken away, then you have a very, very good chance of winning your case, because you're usually there because you weren't paid rent, right? Or you want to move in, or there's a violation of the lease. So assuming all the housekeeping issues have been taken care of, you've done everything correctly, you followed the law, then you should have a pretty good chance of winning your case. So just to summarize, just make sure you follow the rules from the beginning, and then that way your attorney will be able to submit the case to a judge and a jury. And you'll get better settlements, even if you don't want to go to trial. You'll get better settlements because you took away all the affirmative defenses, essentially, right? Because you followed the law.
An affirmative defense is, to clarify for the guys not in ties, affirmative defense is what a renter can say that you did wrong, and that's why the eviction should be dismissed. So you may not have paid your rent as a renter. You may actually be completely wrong by the law because you didn't pay the rent, but it could be dismissed because the renter didn't get the right paperwork related to the notices, like the notices we just discussed. Instant win button, you said. That was an interesting one. I haven't heard you say that. So one example of an instant win button would be if you file the unlawful detainer and the renter doesn't respond, correct? Is that an instant win button?
No, I meant instant win is for example, not posting. It's like when you do tenant defense and you figure out that the landlord didn't do a certain request, didn't follow the law, for example, the right to counsel form posted. Right?
Okay.
That's an instant win. So you know, as a lawyer, for the
renter.
For the renter.
Yeah. Yeah.
The landlord's plaintiff side, you don't get instant win.
Other than if they don't respond, that's kind of an instant win that takes a month or two.
Right.
Okay. I'm using it loosely.
Right. So, but if you're a defendant in an eviction case, you have many instant win buttons, because any time a landlord doesn't follow any of these many rules, there's many of them. Not putting number of bedrooms, not saying Saturday, Sunday, Jewish holidays, right? Not providing an English and the red and yellow notice for the RSO cases that says this property is subject to RSO. All of those non-compliances, you lose. So I call those instant win buttons, right? So you got to take the ability if you want to win. If you got to take the ability from the other side to win on a technicality, so you can actually have a shot at winning the case.
That's brilliant. That's so bare minimum is you have to do everything right as the landlord. The renter doesn't have to do everything right necessarily, but as the landlord you do. And this is I'm not making a judgment about being a landlord or being a renter. We're just talking facts here right now. And then Zach, if you saw a case lost, hypothetically, what would it have been to, in your experience?
Yeah, I think Ralph hit the nail on the head. I think that pretty much every case is won or lost prior to ever filing the case. That Sun Tzu said, victorious warriors win first and then go to war, while defeated warriors go to war first and then seek to win. So if you're looking to win a case in the middle of a case and then saying, geez, how do I win this? You've already lost. You stand no chance. You have to get everything all your ducks in a row, and then you strike. So that means posting the appropriate notices, right? That means making sure that all your rent increases were good, accounting for security deposit interest, little tiny things, little nitpicky things here and there. I get it, life happens, nobody's perfect. But when you're preparing to go to war, taking that time to make sure that it's done correctly and then going to war makes all the difference. So I think that in the cases that we win, It's because we prepared ahead of time to win, and we're successful on capitalizing on our plan. And in the cases where we lose, it typically turns out that long before the person ever met us, they had made some mistake, didn't realize that they were making a mistake. 99% of the time, it's almost never the case that the landlord says, yeah, I knew I was giving an illegal rent increase, but I just thought, what the hell, I'll do it anyway.
Yeah.
Very rarely, right? It's people who make, unfortunately, somewhat witless mistakes years before they, sometimes decades before they meet us, that then we're unable to, essentially finagle, massage, lawyer into, a good outcome. So, yeah, I mean, I think that preparation is one of the most important things. Just having, it almost never comes down to an adverse determination on the merits. It almost never comes down to, ultra, technical, subtle, whatever. Just having some kind of theory of, I was supposed to post this notice and I did. And then maybe somebody came and took it down, who knows? But here's a picture of me posting the notice. Okay, you've got it. You know what I'm saying? It's just that easy. But when it comes to, did you post this notice? I didn't know this notice even existed, right? You were not preparing for victory. You were a defeated warrior seeking to find victory.
Very well said. Is that quote from Sun Tzu on a poster in your office right now off camera, or do you have it memorized?
I do not have it. And I'm sure in the original Chinese, it's I don't know. Not in my wheelhouse.
I think it should be hung up with like a cat hanging from a branch. One of those posters. Okay, so I love these. This is an AB 1482 question. These are my favorite. You guys know I wax on and on about AB 1482. Technically, it's a Tenant Protection Act. So JJ served the rent cap and just cause notice by the end of last year. The tenant never returned it. Then served a notice of change in terms of tenancy given 30-day notice. So yeah, the short answer is, so that form that JJ is referencing, the rent cap and just cause addendum, that's the California Association of Realtors form to give the Tenant Protection Act exemption language. Actually, I don't like that one anymore. My favorite one is the free one you guys have at your website. And the reason I love that one is it actually stipulates that if the tenancy was July 2020 or before, it started before, that you don't have to give the 30-day change in terms of tenancy. And if it was a tenancy that started after July of 2020, you do. So it sounds like you've done what's right. Now, the thing that confuses people too with the RCJC, the rent cap and just cause addendum, is there's a line for the renter to sign. And the line for the renter to sign is in the event that you're giving it with the lease. But if you're delivering it with a notice and change of terms of tenancy, that's what's sufficient. That's what the law says. You don't have to have the renter sign it. So then JJ wants to make sure the house is exempt from AB 1482. No problems. It sounds like you've delivered the Tenant Protection Act exemption language correctly, and you have your exemption. Go ahead, guys, chime in.
Yeah, that sounds exactly right. I mean, I think that there are some people who, and this kind of gets into like ultra technical, people who are defense attorneys who think that, if it's not given at the beginning of the lease for tenancy after 2020, then you can never exempt it, which I disagree with. But they're out there. And sometimes you'll have adverse cases, based on how the notice was given or what have you. But generally speaking, yeah, a 30-day or 35-day if given by mail notice to change terms of tenancy, to amend the lease to contain the required exemption should exempt you from the property. That makes sense.
And then this dovetails into it. So this property is under a statewide rent control only. Individual would like to do owner move-in. Can the notice be delivered by mail only? And that is a valid way to deliver it. You just have to give 5 additional days if it's being delivered within the state, 10 if it's out of state, and 15, I think, if it's out of country. But if you're right, Zach's thinking about it. But
yeah, that's correct. Yeah, so that's only for notices that are either 30 or 60 days. You have this additional option to simply mail it to the tenant Yeah, and then you add time for service, and you'd want to be serving it. Mail it from the county. Don't mail it from China. Just mail it from the county in
Yeah.
California. Yeah.
The for owner move-in under the Tenant Protection Act, SB 567, has some required statutory language and requirements. You have to let them know who's moving in, how they're related, and the renter can ask for proof of that. So this goes back. So Vigilant Bulldog, we were talking about what sounds like harassment, and he or she is basically saying the manager's a realtor and not completely knowledgeable about the regulations, not on top of the changes like we are. So thank you for that. Yeah, so these guys need to be. It's their job. I don't have to be, but why not? Why not understand the darn law? And it's unfortunate. Way too many property managers, whether they're real estate agents or not, because you don't need a real estate license if you're corporate owned and they have one, but they don't take the time to learn. So, all right. So we did that. Let's see. Where are we? All right. Elise, what would be a proper remedy when the rent increase was effective less than a 30 days notice? So I'm going to let these guys jump in, but in order for a rent increase to be valid, for 10% or less of an increase, it's a 30-day written notice. That notice can be delivered in the middle of the month, but then the next month's rent would need to be prorated based on the original rent and the new rent. If it's over a 10% increase within 12 months, then it's a 90-day notice. If it's less than a 30-day notice, it's not a valid rent increase. So if you haven't given a valid rent increase, so let's flesh this out. Going back to what you said, Raphael, about losing cases. If you gave an invalid rent increase and you figure it out, you should peel it all back, shouldn't you, and do it the right way?
All the way back. If you find out that you did a bad rent increase, unfortunately, you have to go back to the point when the bad rent increase was done, and that will be the rent.
Yeah, refund the money. Yeah.
If they've actually paid the rent increase, you would refund the money. Unfortunately, it could be a lot if it was done many years ago.
And how about bootleg units under the RSO? You want to talk about that at all? I see a big smile on Zach's face. Why did I bring that up?
Yeah. So the thing is that for illegal units, you really can't demand any rent. So there are a lot of people who will get themselves into situations without following any of the laws, and then be surprised when the law won't come and help them with their problem tenant who's living in a garage or a closet or whatever.
Even
And
if it's a nice garage or closet, it could be upgraded and spec'd out. But if it's a bootleg unit, illegal unit, it's an illegal unit.
Harry Potter lived in a closet. Look how he turned out. He turned out fine. And so, yeah, unfortunately, LA is not big on garages and closets. And so, yeah, the maximum amount of rent that you'd be able to demand is zero. So, you'd have to return all the rent, and you can be sued potentially for up to 3 times the amount of rent that was collected. So, we've helped people out in situations like that.
So we're talking big numbers. If you've had a bootleg unit for 10 years and you've collected, let's say, 100,000 in those 10 years, then you could be on the hook for 300,000. Is that correct?
Yeah. So you have some statute of limitations issues, but you have some exceptions to the statute of limitations. Most common is the delayed discovery rule. Basically, if the facts are right, you could have hundreds of thousands of dollars in play. It's not uncommon to see, people who put themselves into positions, a lot of times trying to help somebody out, not necessarily looking to make a profit for themselves, so much as help somebody who needs an affordable place to live, turn around and be welcomed, or given for their generosity a lawsuit for hundreds of thousands of dollars. So be very careful about renting out bootleg units. I don't recommend it.
Yeah, no good deed goes unpunished. I hate to say that, but I've talked to enough people who call me, and I know you guys get the same stories. It's no good deed goes unpunished. So, Vigilant Bulldog, your lease stays in effect and cannot be changed unless you agree. Essentially, under the RSTPO, yeah, I mean, the terms of your rental agreement stay in effect, and you have protections based on what limited knowledge we have. You have protections against having your tenancy terminated. They could still do rent increases as long as they're valid under the RSTPO. So
Yeah.
hopefully that helps. All right, so Laker Mark, Raphael, I want your opinion on this. So using UPS mailboxes. So that's like you get like sweet 250 and it's actually a box this big in a UPS store. Is it okay to use that for tenants as for sending notices? Like using that as the return address? And I'd also like to ask, can you use that? Like if your lease references where notices are supposed to be sent, can it be a mailbox?
I don't see a problem with that. Um, I think that the only thing you need to be worried about is if you serve a 3-day notice to pay rent or quit, you would be subject to the mailbox rule. So what that means is if the tenant pays rent, let's say on the third day of the notice, and as long as they put let's say you demanded $2,000 in rent on the 3-day notice, um, the tenant has until the very last day to put the $2,000 in the mail, and it would be deemed like you would be in compliance with the 3-day notice, even though you might receive it 4 or 5 days later when the notice actually expired. Um, Otherwise, if you allow for personal delivery, like most people do, if you don't get the money within a 3-day period, then you could file for an eviction case immediately.
And how about this? What if the tenant, you give them a 3-day notice to pay or quit for 2,000 and the tenant only has 1,000? Should you take that?
You could take that, but you don't have to take that.
Yeah.
So partial payments during the 3-day notice period are discretionary. So you could, sometimes our clients take it and reserve the notice. Sometimes they return it. Depends on the person.
Got it. Just they should ask you, talk to you guys. So we got to thank you. Laker Mark thanks us for doing that. JJ thanks as well. And Jim wants to know, going back to bootleg units, why 3-time damages? That's what the law says, right? why is it 3 times? Because there's quite a few instances of 3 times damage in landlord tenant law.
Security deposit. I think that if you didn't, if you only had damages up to 1 time, then it wouldn't make sense for you to ever return the security deposit because let's just say you keep it and then they sue you and then you have to return it after they sue you. Then it's like, okay, you just did the thing you were supposed to do anyway. So you would literally just, you would never.
It's a penalty.
Yeah.
It's a penalty for not doing it right.
Right. And if that was actually the case, no one would ever return security deposits because.
Well, that's cynical of you, Raphael. I think some people. No, I'm just kidding. You're right. If there's an impetus, and security deposits, I know that we didn't want to go too deep into this. Security deposit law changed. You now have to have 3 sets of pictures. So. And that's for tenancies that started July 1st, 2025 or later. So you need pictures when they move in. Any tenancy that ended after April 1st of 2025, you need 2 sets of pictures. That's related to returning the security deposit. It's pictures before you do any work and cleaning, and then after the work and cleaning. You have to deliver those pictures. Some areas have interest that must be paid. Tell me more about the interest on security deposits.
So for example, in the city of Los Angeles, if you are a landlord who has a security deposit for, let's say, a rent stabilized property, so you've got more than 2 units on a lot, or 2 or more units on a lot, you'll have to pay interest annually. There's 2 ways to do that. You can cut the tenant a check, or you can deduct it from the rent. That's the more common way to do it, is to just deduct it from the rent. The Los Angeles Housing Department annually comes out with an interest rate. You could also, if you'd like, simply deposit the money into an interest-bearing account and then give the tenant like the actual interest rate. Hardly anyone does that. Could. In reality, what you do is you just simply have a calculator, and you calculate what, for 2025, what the interest is going to be. And then, as it rolls over to 2026, you, for their first rent payment, credit them the annual security deposit amount. And if you haven't done it in the past, you should do it now.
Yeah, and you can lose an eviction over that.
You can lose any kind
correct?
of eviction over that. So even if you had, let's say Ayman al-Zawahiri, or maybe Khalid Sheikh Mohammed. Khalid Sheikh Mohammed gets out of Guantanamo Bay, is planning another 9/11 in the city of Los Angeles, and you want to evict him, send him back to Guantanamo Bay. Can't do it if you haven't paid him the security deposit interest. So yeah, yeah, any kind of eviction can be stopped stone cold in its tracks by failure to pay what's often a trifling amount of money.
All right. So we're going to wrap this up, gentlemen, and I appreciate your time. We're actually in the way. I'm going to see if I can move us out of the way. Oh, now we got technical difficulties here. Maybe Michelle can help in the background because it's blocking. Get us over to the side, Michelle. But we are going to be, there we go. Thanks. See, that's why I love Michelle. She's so handy to have in the background because I screw stuff up. Oh, there's more questions. Maybe we'll go back to it. The rent gouging. I do want to talk about it, but so we're going to be at the AOA trade show. It's the free $1 million trade show and landlording conference. That is next week on the 20th, not Wednesday, at 9 a.m. We're actually going to be doing we're going to be up on the main stage. So if you, after hearing this, want to hear more of us, which I know is a lot to ask, but if you want to hear more of us, you can come and join us at 9 a.m. We'll be in Area A. We're going to be talking about surviving the current ice age for landlords. It's more than just a metaphor. The fact that rent was frozen during COVID for landlords, and now the fact that LA County has a cooling ordinance coming. There's some actual literal angle to this ice age metaphor. So we'll be there next week. Should have either one or both of Raphael and Zach on the panel with me while we talk about this. Kenny will not be there. I know. I'm very bummed. He's out. He's having a vacation, which Raphael and Zach said is against the law for him to do. So that's it for tonight, guys. Really appreciate you being here. Oh, wait, whoa. Slow down a minute. I forgot to ask if I'm looking for an eviction attorney, even before I'm looking for an eviction attorney, like I don't need one. I should just have one in my quiver because I'm a landlord who's ready for anything. Why should I hire you guys, Raphael? Why hire your team?
We win. We follow the law. We communicate with our clients, and we're passionate and we love our jobs. We love helping landlords. So reach out to us and we'll be glad to help.
Zach, why should I use you other than fabulous?
I was just going to say, because you already, as a master of strategy, that we win a lot. We've been able to help a tremendous number of people. We've been very grateful for people trusting us with their business. And if you've got a problem, we'd love to help you solve it. So.
All right. So two last questions. I'm sorry, guys. I'll let you go. I promise. Rent gouging law got extended. Is there a clear threshold on what qualifies as gouging? Yes. And I'm going to let these guys jump in. Penal Code 396, I think it is. So for LA County only, it was extended through the end of August for rent. The Penal Code 396 talks about more than just rent. It talks about like price of bottled water, a bunch of random stuff, not specifically, but supplies. Rent portion for LA counties extended through August 31st. It is canceled for other counties like Orange County. It ended in end of July for Orange County. And yes, even though the fires were in LA, it also trickles up to the counties around there. And then the threshold for gouging is anything above 10%. In many cases, if you have a property that's subject to the RSO, you couldn't even go up 10%. You can go up 3 or 4. If it's subject to the Tenant Protection Act, you're capped at 8%, so you couldn't go to 10%. So this would be properties exempt from the Tenant Protection Act, like houses and rent increases. And then this also applies to a renter moves out and the new renter moves in. Anything to add, gentlemen?
There's also some provisions regarding properties that weren't rented. So let's say that you were living there and thus there's no previous rent, using fair market rent values to calculate the maximum amount of rent that could be charged. I think that if you're looking to take on a new tenant for a property, maybe just wait a couple weeks if they don't keep extending it. But yeah, I would sidestep the issue entirely and advise people to just wait to start up with new leases, and then you'll avoid any problems.
One more question from Jim. I think I know which Jim this is. Jim, hello. Is there a situation where a buyer at a trustee auction who wants to move into the rental unit but can't evict the tenant for various reasons? Yeah. Just because it goes through an auction does not mean that the rent stabilization ordinance doesn't apply anymore. So if you happen to be lucky and buy a duplex that's under the RSO with a pair of renters in there that are over 62 and have been there for more than 10 years, you aren't going to be able to use owner move-in on either one, but you could use Ellis Act. But that's a different ball of wax. Anything to add, guys?
Yeah, just quickly. So let's say you were purchasing it, or excuse me, you bought it at the trustee auction and the previous owner is still there. You're basically in a race with the previous owner. If you can start your eviction, if you can get your deed filed, recorded with the county or recorder's office, and serve your 3-day notice prior to them filing what's called a lease pendens, you're going to have an easy time. If they strike first, file a lease pendens, you're going to have to wait until that lease pendens is either expunged or otherwise removed. That can take years. Yeah. So move quickly. When you get the deed from the trustee auction and you file and record it with the county recorder's office, come grab us and say, hey guys, let's go, and we can help you out. But if they if they record a lease pendens, you could be waiting to move in for quite some time.
Yeah. And there's differences too. If it's previous owner versus a renter, the renter may have a lease. You got to honor the lease. So that's it. All Nighter was here. Good to see you, All Nighter. And Vigilant Bulldog, good to see you. And very good to see you too. And I'm going to see you next week, gentlemen. So thanks for coming out. Make sure you subscribe, like, and all that fancy stuff. And go visit California Property Law Group's website. They have amazing forms. And we will see you again soon. I'm dragging you guys back in another month. All right. You can't